Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Welcome, everyone, to the Empowering Plans Podcast. This is Corey Crigger, and with me for the first time, not her first time on the podcast, but the first time that we've been able to do this together, which I'm very excited about, is Kelly Dempsey. Kelly, how are you today?
Good. How are you?
I'm doing great. Well, I'll just go ahead and get it out there. As you could probably tell, those of you who listen to the podcast, I have a lot of small kids at home, and there's a slight head cold running through the Crigger family. So I'm a little nasally today, but I couldn't pass up an opportunity to join the podcast with Kelly because although we've worked together for quite a long time, our paths don't cross too frequently. It's usually at conferences or at forums. So I'm excited to hop on here and do this podcast with you. And frankly, I'm tired of doing podcasts with Nick. So I'm glad that you could join me here today, Kelly.
Yeah, I was getting a little tired of Kevin. It was time for a change.
You got to keep it fresh. And that's what we're trying to do here on the Empowering Plans podcast. So as you could tell by the title and the description, we have a theme at the podcast today. It is back to school theme. School districts around the country are going back to school, and we're going to take you to school a little bit today with some of the happenings that we have going on in the industry. But before we jump into why we're really here, unfortunately, here in Louisville, we're making some regional and some national headlines with how our back to school day started. Kelly, have you heard anything about what's going on down here in Louisville?
No, I actually haven't. But admittedly, I like to hide from the news.
Hey, listen, that's a great strategy. Unfortunately, Jefferson County Public Schools, they hired a very cutting edge AI company to do the bus route logistics for our back to school week. And our first day of school last week, the last child was not dropped off until 10 p.m. with no one able to locate their kids. It was a whole ordeal. So we have canceled school this entire week. We're going to pick it up again the day that this podcast drops. So Friday, the 18th, we're going to try it again. So hopefully their back to school goes a little bit smoother than what it went last week.
Oh my goodness, that's insane.
I can't imagine. But, we're not here to talk about the Jefferson County Public School System as much as I may or may not want to. We're here to take some plan sponsors to school and to educate them. We got some cases we're going to talk about. It's renewal season as well. But really, the first thing we want to talk about in our our very heavy school-themed podcast is FIA University, Kelly, which is something that I'm really excited about, and I think you're excited about as well. Why don't we talk about FIA University here for a minute?
Excellent. Yes. So we are super excited to be able to share FIA University, specifically with our ICE clients. Our ICE clients get exclusive complimentary access to our FIA University, which is our new internal platform that we are launching internally for our own staff, and then additionally for our ICE clients. We have several modules that are already completed, and they're only about 15 to 20 minutes a piece. I think that's the number one concern when we talk about any type of training is, putting individuals behind a computer and making them just watch unending videos. So they're only about 15 to 20 minutes a piece. Right now we have 4 that are planned and done. It's the basics of health insurance, the basics of self-funded health plans, because that's obviously a little bit different, health plan participant education, and then plan documents. We are also have a couple that are in progress, which is a Mind the Gap, as you can imagine, is about gap reviews and all the fun things that come with that, as well as a mental health parity section, because that is obviously the NQTLs are crazy, running rampant. The DOL is continuously trying to push out new information, which kind of leads me into my next topic about renewal prep. So 1/1 is just around the corner. I'm still not really sure how we're in the middle of August already, but here we are. So there's a laundry list of things. And, like Corey said, we are kind of on a back to school theme. It's also the theme of our webinar this month for August. And you're going to be hearing a lot about it because this is the time where everybody starts prepping for those 1/1 renewals, which are right around the corner. So a couple high level things that we have that are going on. As always, the IRS has issued some updates related to the HSA contribution limits and the high deductible health plan out-of-pocket limits and minimum maximum contributions. So the HSA is really interesting this year because we know the IRS increases these rates every year, but we are seeing one of the biggest increases in HSA contribution limits that we've ever seen. So it was actually about a little over, almost close to 8% for the self-only contributions and about 7% for the family contribution. So big increase from 33,850 in 2023 to 4,150. So it's good to see that, it sounds like the regulators are actually hearing us when it says individuals need this kind of help. So that's exciting, something to be aware of. In addition to all the high deductible health plan stuff, the ACA out-of-pocket limits also increased for next year. That's been going on every year since 2014, so it's not really anything new. And there's no huge surprises there. They've gone up incrementally. There's definitely been a couple of changes to the ACA preventive care requirements. So if you're not familiar with that, every 5 years, there is a rotating cycle, and it's not like every 5 years it happens. It's constantly, but all of the different requirements under the preventive care, so those HRSA and the U.S. Preventive Services Task Force ratings get analyzed and assessed on a regular basis. So every year they push out the updates for whatever ones are up in their 5-year cycle. So there's a couple new ones, as well as just affirming ones that already exist. New requirement that's happening technically at the end of this year, so it's 12/31 is the due date, is the gag clause attestation. So that's obviously new. We're continuing to maintain the transparency and coverage information, all the No Surprises Act stuff. It's hard to believe we are in year 3. I know, it's so crazy how fast time flies. And then the mental health parity proposed rules, which the good thing is that while those proposed rules just got issued within the last couple of weeks, the ETA on the actual effective date of those would not be until 2025. So it wouldn't be a change for 2024, but it is still important to know because, the regulators are definitely publishing those proposed rules to talk about additional ways that plans need to collect and evaluate their data related to the non-quantitative treatment limitations, the NQTLs. So, there already are certain requirements, but this guidance is trying to clarify and make better understanding of the network adequacy and other factors related to those NQTLs, because I think that's where we've seen a lot of shortcomings when we've been doing our NQTL analysis that is required for plans to have each year. So it's another service that we can help with. But that's something that, again, it's been around for a while, but it's important to talk about because it's not going away. It's an annual requirement. Technically, plans are required to redo it and update it each year. In theory, it shouldn't change a whole lot from year to year unless the plan is actually making benefit-related changes. But obviously, assessing the data on an annual basis can always change things because, sometimes certain years' claims are higher than others, and that just, makes a mess of things. So with that, since you're probably tired of hearing me talk already, I will turn over to Corey to talk about a couple new and interesting cases that are on our radar right now.
Absolutely. And Kelly, you mentioned gag clause attestations, and that is something that, we've seen a lot of questions come in. And even earlier this week, I had to reach out over to a member of your team because of some language wanting to be put into just a balance bill settlement release that was basically going to bind the health plan to not talk about the terms of this settlement agreement and not discuss it with anyone in the confidentiality, and saying that the pricing and the discount and the build charges are proprietary and entering into a confidentiality agreement for just a balance bill resolution. And Andrew and I talked about it back and forth for a little bit, and we ultimately went back to the provider and said, hey, we can't recommend this language because of this prohibition that's coming up. So you're seeing it a lot of places. We're keeping an eye out for it, even in just settlement releases for balance bills, and thinking through some language there and making sure that you're crossing your T's and dotting your I's where you need to. So always a good reminder there. Yeah, so there's some great cases that we're keeping an eye on here over on the provider relations side of the house, and they're all related, shockingly, to the No Surprise Act. It's been such an easy piece of legislation that has seamlessly been adapted and everyone has followed it to a T. I'm just shocked that there's been lawsuits around it, and I say that very tongue-in-cheek if that can't be picked up through the podcast media. But there's 3 cases that I want to talk about today, and they all have slight different wrinkles that find them interesting. And the first one I want to talk about is Reach Air Medical versus Cigna Health. And what Reach Air Medical is alleging is that Cigna Health is sitting on almost $3 million of unpaid IDR determinations across 29 different states in which air ambulance services were provided. An initial payment was made. There was an open negotiation period, and then ultimately went into the IDR process. And there were determinations from the IDR entity saying that Cigna needed to pay additional amounts on these individual claims, and all those claims add up to almost $3 million. And Reach Air Medical has not been paid. Now, the interesting thing is, we looked at the complaint. They did not attach the IDR determinations in any exhibits that I was able to access and look at. But it will be interesting as this case progresses. Was notice proper? Did Reach Air Medical get the notice of IDR to the right party at Cigna? Were these defaults? Was Cigna aware of it and just didn't respond in time? Did Cigna put together offers and the IDR entity just sided with Reach Air Medical? All that stuff I think is going to come out as the lawsuit progresses, but we don't have that information in front of us now, but we're keeping an eye on this case for that reason. And then there's basically 3 buckets of allegation that Reach Air Medical is making. That Cigna didn't pay the claims within the 30-day window prescribed by the NSA. And that makes this case interesting to begin with, because we're looking to see if can a provider go to the civil courts to enforce the administrative policy of the NSA, because that's basically what this is going to boil down to. They're also alleging that there was improper denial of benefits under ERISA. And then the third allegation is that once IDR determinations are made, then state prompt pay statutes come into play. And not only did Cigna not pay within the 30-day window prescribed by the NSA, but they're also not paying within particular state prompt pay statutes. Now, the interesting thing about this, and it was something that Cigna brought up on the motion to dismiss that they filed in July, is that this case is being brought in the Southern District of Texas, which is very friendly to providers. That's where all the litigation that led to halts in the IDR process came out of that Southern District. But they're alleging that, hey, if you're talking about 29 different states' prompt pay statutes, it is improper to have the Southern District of Texas to interpret any other state prompt pay statute. So they're really hammering home, challenging that this is improper venue. As recently as I think Thursday of last week, there was actually an answer to the motion to dismiss that Cigna filed, and then there was an extension granted on the 11th last week. So this is very active. We're keeping an eye on it. I have my alerts set on Court Listener to keep an eye on how this case develops, but that is one case that we're keeping an eye on.
You're gonna make me have like nightmares about law school, about venue and proper venue. That's taking me back to the civil procedure class. That was a long time ago, longer ago than I care to admit at this point. But what you said is interesting about the notice requirements, because for those of you who don't know, I used to work at a TPA many years ago, since I've been at FIA for almost a decade. But we had some significant challenges with Cigna when Cigna started moving into the self-funded space, and then also had their fully insured business, that we had a mess of our claims situation with claims going to the wrong places and therefore not getting paid timely because they were going to fully insured Cigna versus self-funded Cigna. And so that's interesting. I mean, I'm glad they actually, obviously answered the lawsuit, but I think this venue thing will be interesting. And I guess for those, lawyers of us that like to geek out on this stuff, it'll be interesting to see if it forces Reach to have to file 29 different lawsuits in 29 different states.
Absolutely. And, Civ Pro 1L year, the only thing I remember is, do I have sufficient minimum contacts? And that is a very inside joke to only lawyers that are listening. And we're just going to move right on because it was a bad joke as well. So, FHMC versus Blue Cross Blue Shield of Arizona. So FHMC is a freestanding emergency room. They are not contracted with any insurance company, and they are suing Blue Cross Blue Shield of Arizona. And if you read the complaint, like I did, you can see that they are very proud that they are non-contracted with any health insurance, and they have a noble mission of making sure that they can provide care to all individuals regardless of their insured status. And they're suing Blue Cross Blue Shield of Arizona. And they're basically making allegations on 2 different buckets of claims. There's claims that were paid from March to December of 2021. And what they are saying is that when patients treat at FHMC, they assign the benefits that they're due to their health plan to this freestanding emergency room, and that Blue Cross and Blue Shield of Arizona knowingly sent member benefits directly to the patients. So they're basically making assignment of benefits argument on this subset of claims. And this is very interesting to me, Kelly, because we make a very similar argument when we're talking about providers receiving member benefits in the RBP space, right? We make the argument that, hey, provider, by accepting the benefits that the member was entitled to, you are also accepting the rights and obligations that the member has, which means you are only entitled to the same amount of benefits that the member has. Here, we have a provider in Arizona saying, hey, the benefits were assigned to me. You should have to release the funds to me, and it's improper for you to do anything else with these funds except release them to me. So will we be able to pigeonhole? Will we be able to make our AOB argument a little bit stronger in the state of Arizona? That's one reason I'm keeping an eye on this case. It will be interesting to see how that plays out. And then the other subset of claims are the claims from 1/1/22 to present. So those claims that are going to fall under the No Surprises Act because they incurred after 1/1/22. And what they've said here is that Blue Cross Blue Shield of Arizona is severely underpaying claims. And they are alleging that prior to 1/1/22, the average ER claim for FHMC was reimbursed by Blue Cross Blue Shield of Arizona at 47% of billed charges. For all claims 1/1/22 and forward, up to the date that the suit was filed, FHMC is now receiving 5% of its billed charges on average. So Blue Cross Blue Shield has cut, allegedly, how much they are reimbursing ER claims to as low as possible, it seems. And they are challenging whether or not that they are correctly applying QPA methodologies and what the methodology behind the QPA that Blue Cross Blue Shield is calculating. And this is interesting because it is very, in the IDR process for No Surprise Act claims, it's very clear that you cannot challenge the QPA calculation in the IDR process. Can you challenge it here civilly? That's going to be what the crux of this is. Can you challenge the payment methodology? And I know that, 2 years ago, Kelly, around this time, we were getting a lot of questions from a lot of clients. Hey, what can we do with these NSA claims? We just want to pay them as little as possible. We want to pay as low as possible. And I was on a lot of calls where we talked to a lot of clients and said, we really encourage that there be methodology behind this. And this right here is example 1A of why, because the QPA is now being challenged civilly, and we're keeping an eye on this to see where this one goes. And then we have one other case that I'm going to talk to, and I'm going to throw it over to Kelly to talk about the Department of Labor for a minute. This is brand new. It was filed August 9th. It's the Association of Air Medical Services, and they are suing the Department of Health and Human Services, or HHS. The Association of Air Medical Service boasts that they represent 93% of all air ambulance carriers nationwide. And what they are alleging, and I'll just read straight from the complaint here because it makes it the easiest. The plaintiff contends that the Department of Health and Human Services are implementing a definition of QPA methodology that intentionally lowers the QPA for air ambulance services and runs. And this is contrary to the NSA statute in 3 ways. 1, it excludes most types of contracted rates between air ambulance providers and plans and insurers. 2, they treat hospitals and independent air ambulances services as providers in the, quote, same or similar specialty. So they're saying that they're treating hospitals and air ambulance services the same, and you shouldn't. And then 3, that there is an overbroad geographic region that generates the QPA, and I love this, that is wholly divorced from real world pricing in reasonable geographic markets. And Kelly, having an air ambulance company use a term wholly divorced from real world pricing is ironic in multiple levels, seeing as I've seen 35-mile air ambulance transports bill for 6 figures. So maybe they should look a little bit in the mirror at who is wholly divorced from real world pricing here. But this is a brand new lawsuit filed August 9th. We're keeping an eye on this as well to see what's going to happen with the QPA methodology there. But those are 3 cases that we're keeping an eye on over in provider relations that have NSA implications, Telly.
I almost feel like there's some of these providers who are working with law schools to give challenges of who can come up with the most creative argument to make with all these rules and regulations. So it's definitely interesting, especially because these are not the cases I look at on a daily basis. So it's interesting to hear about these, and I can't help but feel like there's some sort of contest behind the scenes for who can come up with creative arguments to challenge these new laws and processes and procedures. So
and we are all the losers in this contest, Kelly. That's what I've learned.
This is true. Well, hopefully we can talk about, another case that there's no winner or loser yet, because again, similar to some of yours, it was only filed just recently. But the Department of Labor has filed a lawsuit against UMR, which is a subsidiary of United Health Group. So UMR is the United States' third largest medical claims administrator, which shouldn't be a surprise to anybody. But there's allegations of improper denials for thousands of emergency department claims, as well as drug screening claims that, again, allegations that these claims were processed improperly from the beginning. So the first piece of it was related to the emergency claims, and that there was a list of codes that claims were being processed against. And if the codes weren't on that list, the claims were being denied. So this doesn't align with the prudent layperson standard, which has been evolved under multiple federal regulations. So there's been some guidance under the ACA, as well as ERISA, as well as EMTALA, which, talks about emergency services in general. And effectively, that prudent layperson standard is something that I don't know about you, but I did actually learn about in law school, because I did take a healthcare law class. I'm not sure that it came up in any other class, at least not in this context. There are multiple versions of prudent layperson. But what that means is that if an individual is having what they believe to be a medical emergency, you have to look at and process the claims as to whether or not it's an emergency according to what that person would have been thinking or feeling. So the average person, what they're thinking and feeling. And I know that Corey and I have, we were swapping some stories when we were preparing for this podcast, and we both have situations where us, especially operating in this industry, didn't necessarily think things through the way probably a prudent layperson would have. But, there's situations where we thought we were having a medical emergency and needed to go to the emergency room. And in those cases, those claims definitely need to be treated as if they were an emergency. So it's not as easy as processing claims against a list of codes, because if those codes don't show up because it's not truly an emergency, at least from a medical perspective, it could still be an emergency from the individual's perspective. And I feel like this is a tale as old as time when it comes to claims processing, and has been a challenge for all claims administrators across the board. It's just, this I think is probably a process that has been followed by more than just UMR. So it's kind of a call to action for all of our TPA clients to look at the way they're processing claims, because there's a lot of different ways that things can go sideways. And the implications here are huge, because they're talking about claims all the way back to 2015. That's a lot of claims. So they're specifically looking for a certain type of claims when it comes to the drug testing and urinary screenings. They're talking about 2015 to 2018, because in 2018, there was a change to the claims processing. But that's still going back a really far way. We get questions all the time in our consulting department about the VA and VA claims and how long Medicare has to come back after a self-funded plan, because the filing limits under those plans are a little bit different, a little bit unique. So, the implications here are huge. Like, I don't necessarily know that any of these claims would be significant unless there was, in and of themselves. But if there's a lot of them for one employer, there's obviously stop loss implications are completely off the board, because your stop loss policy is not going to cover any sort of claims from 2015 to 2018. So it's huge. This is a very interesting case, and it'll be interesting to see what comes of it. But there's also some allegations of improper detail related to the denials going to claims participants, which, that's a big thing that we get asked all the time. And there's obviously been changes over the last couple of years to the explanation of benefits to make sure that they are clear and that there's a specific denial reason on the plan, and that it ties to language in the plan document and all those things. So this is just another one of those factors being highlighted, especially because things have changed over time. So there's huge implications with this one as well. And like I said, it was only just filed. I think it was filed at the end of last week. I don't know. I've lost track of time already, but it's only been filed within the last 2 weeks. So the request for resolution here is that the Department of Labor is asking for claims procedures to be updated so that UMR changes how they're processing claims, that they reprocess all those claims since 2015 to stop them from committing future violations, which is, one of those fun legal terminologies of enjoining them from committing future violations of ERISA, which does that really mean? Who knows? And then anything else the court finds just. So there could be monetary penalties. It's hard to say. It depends on what they find and whether or not there's some sort of willful neglect happening here, or if it was just a mistake, or what is found. But this has big implications. There's no dollar amount that's linked to it, similar to like the Reach Air medical claim case that Corey mentioned, where there's almost $3 million on the table. There was no dollar amount thrown out with this just yet, but I'm sure that there's a dollar amount attached to all of these claims in existence, and that's probably going to come into play when it comes to this lawsuit. So yeah, super fun. Lots of things to talk about as we all go back to school effectively for all the new things that are happening and to make sure we're not missing anything. So if you have any questions about any of these cases or anything else, obviously feel free to reach out to us. And if you're interested in FIA University and want to hear more about our ICE service and access to that, we're available for that too. Any other closing comments you want to add in, Corey?
Yeah, Kelly, it's so great. We had a client that came to us and they said the eerily similar fact pattern, only they were determining no surprise act claims based just on straight codes. And we had to have this conversation of like, well, the No Surprise Act says that emergency treatment is, would a reasonable person expect to be able to get that care at, and is it the kind of care that the average emergency room would offer, for lack of a better terms, without quoting the NSA directly. And this Department of Labor versus UMR, the fact pattern is almost identical to what we talked about, only it was with NSA claims instead of the ER claims that you have here. And it's just interesting to see that there's nothing new under the sun, it seems. There's only different labels and different times that issues pop up. But yeah, it was a great time today. I'm happy that we were able to do this together. And, we all know that Alice Cooper was wrong, that school is not out forever. And hopefully that everyone listening today was able to take away a little piece of information that you didn't know. And we were able to make someone think through a process or learn something new. And if we've done that, I think we've had a successful podcast. Don't you, Kelly?
Yeah, I do. And with that, I'll say class dismissed.